You are listening to the podcast of Indian Link Radio, Australia's first 24/7 Hindi radio station available on iTunes and Android. And this is Sagar. In today's podcast, we are going to talk about estate planning, creating your will or vasihat in Hindi that protects your family after you're gone. We work hard to give best for our family. But what after your time is up? That's why estate planning or creating a will is necessary. Will is often considered to be a thing of someone who is rich or old, but the fact of the matter is, it's about responsibility and protecting your loved ones, no matter your age or how much you own. Today, we are joined by Melbourne based lawyer Simran Joshi, Senior Associate Lawyer at Eastern Bridge. I will let her introduce herself, but before I do that, just a disclaimer. The information provided here is for general purpose only. Please consult your lawyer for situation specific to you. Welcome to the podcast, Simran. Please tell our listeners about yourself.
Thanks for having me, Sagar. Hi, everyone. I am Simran Joshi. I'm a wills and estates lawyer at Eastern Bridge. Now, we are a law firm in Baldwin in Victoria. And I am a dual qualified lawyer in Australia and India. And I work with individuals and families to put the right legal structures in place, things like wills, powers of attorney, and strategies to protect assets and reduce disputes.
Right.
So a big part of what I do, Sagar, is helping people plan for the unexpected.
Mm-hmm.
So their loved ones aren't left dealing with confusion, delays, or any kind of conflict. We can't totally avoid conflict because it happens if it has to happen, but
Absolutely.
we can do the best to reduce it.
Yeah. It's a taboo subject and not many people want to talk about it, but then it is required, it is necessary to understand what are the intricacies behind it. So I'll jump into few questions that I am really curious to ask you, and I'm sure my listeners would be very curious to understand them as well when you explain. I'll start with the first question, Simran. When someone sits down with you for the first time to make a will, what actually happens in that first meeting? And what's the big thing most people forget to mention?
That's a good question, Sagar. But before I answer your question, I would like to give a disclaimer here to listeners. So just a quick disclaimer before we begin. What we are talking about today is general information only, and it's not legal advice, and it may not apply to your personal situation. So if you need advice about your circumstances, it's best to speak directly with a lawyer who can review your situation properly and give you tailored advice.
Absolutely.
All right. So having said that, coming back to your question, in simple terms, Sagar, that first meeting is all about to get to know the client better, getting the basics clear, who is in the family, what they own, what they want to happen if they were to pass away. So basically the family structure, the assets, and what the goals are. Okay?
Right.
And in terms of when we talk about assets, it's important for me to know in that initial meeting how the assets are owned, whether they are owned jointly, like the spouses own it jointly with each other, or they are in sole ownership in some situations. So how they are owned is very important.
Yeah.
What people don't realize is there are two ways one can hold a property as joint. Most people don't really know that, and that's very crucial and very important for succession planning and to when you're preparing your will.
Right.
So there are two ways you can own a property joint, something called joint tenants and tenants in fee. If you're holding a property as joint tenants, it will not form part of your will. It doesn't form part of your estate. It directly goes to your spouse on your passing. So the surviving spouse inherits it as whole, so It doesn't form part of the estate. Whereas tenants in common is dealt differently. Now, knowing that difference is very important, and that's why I insist on, looking at the certificate of title for those properties before we, do the wills and start the drafting. The other thing that is important is if the clients have minor kids,
Mm-hmm.
whether they have thought about who could be a guardian for the kids. So that's an important detail that goes into the will. Another thing that is very important for a person to think about
Yep.
when they are doing planning is who they would want to appoint as executor. So executor is somebody who executes the will after you've passed. So that's a very important role, and it's important to think very, very clearly as to who you want in that position.
Correct.
And also think of
Mhm.
who could be a backup. So, for example, the executor that you appointed in your will predeceases you, means he dies before you die.
Yeah.
So, have you put the provisions for backup executors in the will? Otherwise, you need to change your will again, and obviously, if you fail to do that, it could be a problem. So these are the basic things that are discussed in the initial meeting, Sagar.
That's a very important point that you've just mentioned. And I'd like to ask you a follow-up question, Simran, over here. Can an executor and beneficiary, which normally in a scenario, well, let's say if in my scenario, can my wife be the executor and beneficiary both, or they have to be different?
No, yes. The beneficiary can be the executor. In fact, it is good for a beneficiary to be the executor because they have the interest in executing your will.
Right.
So that is a very usual situation. People appoint, in cases of spouses, they appoint each other as their executors in the first place, and as a back, then they have other people. For example, they might have their siblings, or if the children are adults, they could have their adult children as backup executors. Yes.
Fair enough. Next question, Simran. A lot of parents worry about their kids could lose the inheritance through either divorce or debt, addiction, or just bad decisions. Is there a way to protect it without cutting them off?
Sagar, this is a really common concern, and yes, there are options. There's something called testamentary trust. Now, most people know what wills are, and when we are talking about wills, we are mostly thinking about a standard will where everything is going outright to the beneficiary. Like, for example, if everything goes to my wife, absolutely. That means it's not going through any structure. She or he inherits it, absolutely.
Yeah.
But one of the main estate planning tools is something called a testamentary trust, and that's when we prepare those kind of wills which have that structure. So rather than giving all the money outright, you give it in a structured way through the use of a testamentary trust.
Right.
The other thing you could do is have staged inheritance, like age-based. For example, 18 is the legal age for any child to get the inheritance.
Mm-hmm.
But 18 is too young for children to get hold of a lot of inheritance. Suppose it's in millions.
Yeah.
Then they could have those say that no, they can't get it until they're 25 or 21 or whatever age they think would be a suitable or appropriate age for them to inherit, so that they don't waste that inheritance or to secure and protect it. So that's another way.
Right.
Also, it's important to have the right people in control, and I mentioned this earlier, as the trustee of that trust. So who's in control of the trust? That's something that one needs to think about.
Mm-hmm.
These trust structures also protect from bankruptcy risk, creditors risk, and to somewhat extent, it also protects from relationship risk. So it's not a total shield, but reduces exposure definitely.
Right. And does a beneficiary have to be a certain age? How old must be a beneficiary to inherit?
You can have it at any age, but you have to also think of practical implications of what you put in your will. I had a client situation where the daughter who got the inheritance, the will said she gets it at 45, and
Oh.
at 43 was detected with cancer. So, you know, she wasn't too happy about the whole thing because she's going to die in the next, few years or some time,
Yeah.
and it's too late, too little, too late, kind of a thing. So
Right.
it has to be a reasonable age where you want to make a balance
Yeah.
in terms of when you want the children to inherit it. They should, they are wise enough to make those choices, financial decisions, but not too late also.
True.
I
True.
would say.
Okay, here's a common scenario, Simran. Couple owns the house together. One partner dies. The survivor later remains and has more kids. Can the new family end up with a share of the original home?
Okay, that's a good question, and the short answer is yes, it can happen, and it depends on the situation actually.
Right.
How the property is owned, how the house is owned, whether it's as joint tenants or as tenants in common. I had mentioned earlier about that being an important distinction.
Yeah.
So let's presume if it's owned as joint tenants, it passes to the surviving spouse automatically. So he or she inherits it 100%.
Yeah.
It doesn't form part of the will. Now, when it comes to the surviving spouse, they become the sole owner of that house, right?
Yes.
And from there on, it will depend on whether that surviving spouse has prepared a will or not, right? So, for example, if they have not prepared a will, then the intestacy provisions will apply. Now, intestacy means somebody who dies without a will is called, he or she has died intestate.
Right.
And what happens when somebody dies intestate is that the legislation has a will ready-made for you. Broadly, this means everything that you own will go as per the complex hierarchy and provisions in the legislation. So trust me, they are really complex. So there are, various scenarios. If there's a partner, if there are children from the same partner, children not from the same partner, blended situation, all of these situations will have different outcomes. So it's a complex scenario, and definitely it will not go as per your wishes. So it's best to do a will rather than relying on these intestacy provisions in the legislation. And mind you, every state in Australia has different rules, so it will also depend on that.
Okay. And will testamentary will or planning help in this situation?
So if you're saying testamentary trust will for the surviving spouse,
Yeah.
or in the first situation when the original spouse died.
In the surviving spouse.
Yeah. So if the surviving spouse does a will
Yeah.
and creates a testamentary trust structure,
Mm-hmm.
that there can be protection.
Right.
They can be protected because the surviving spouse has inherited the house in their own name, and they are able to give it through their will. Whereas in the first situation, there is an automatic survivorship rule application, and it doesn't come into the will. So it's quite complicated, as you can see, and it needs tailored advice.
Of course. Now, I want to touch upon superannuation briefly along with the estate planning. We all know super can be someone's biggest asset. So does your will automatically cover your super, or is that a separate decision?
Now, most people don't know about this, but the key thing to understand here for super, Sagar, is super is usually outside the estate.
Okay.
So, and you rightly said it's your biggest asset in Australia, and so super doesn't come into the will. Interestingly, right? And super is dealt with by something called a beneficiary nomination. Now, the nomination may be, it may be binding, non-binding. There are various options that you'll see on with these super funds, like retail and industry funds. There could be lapsing binding, non-lapsing binding, and they all have different rules around it.
Yeah.
Important thing to note is there are also specific categories of people who you can nominate. Otherwise, your nomination will be invalid. So it's best to these rules are complex, and so it's best to take legal advice. Yes, when you ask the question, your will, how it relates to your will.
Yeah.
Yes, align your superannuation with the will, so there shouldn't be any contrary or conflicting instructions in your will, directions in your will. So that will reduce the dispute and any kind of delay.
Okay. What is binding nomination, Simran?
So binding nomination is you are binding the trustee to give your superannuation death benefits as per the nomination that you have created, and there are rules around that. It has to be in a certain format, and it's very strict about it. It follows the legislation, which is the Superannuation Industry Superannuation Act 1993, and it has to be exactly according to the Act and the regulations.
So how is it different to the normal nomination?
So what do you mean by normal nomination?
Say there are two options, I believe. One is the binding nominee and the other one is nominee or beneficiary.
So the other is a non-binding, right?
Right,
so
non-binding.
Doesn't bind the trustee. The trustee may consider it, but may not go by your non-binding nomination, right?
Okay.
Binding is something that if you have completed it correctly and it's held to be valid by the trustee, then the trustee has to follow it. So that's the difference.
Okay. Now another scenario, Simran. So if there is a family emergency after someone passes away, can an executor dip into the estate to help a relative who isn't even named in the will?
That's a great question, Sagar, but the short answer is no. The executor position is actually a fiduciary role, and the executor must follow the will to the T. So they have to go as per the will. The only thing that the executor can do, they can only pay reasonable expenses and all the liabilities of the estate.
Yeah.
And so the liabilities are paid off. Whatever is left is distributed to the beneficiaries, but who are beneficiaries in the will. So the answer is no. Estate funds aren't a family support fund. The executor has to be very careful and has to follow the directions in the will. Now, there are many times, clients ask me this question. So I've appointed as executor and they will decide how my assets will be distributed. No, that's not the role of executor. If fiduciary role, if they do anything wrong, they could be personally liable for it.
Right. Simran, the majority of the Indian migrants over here in Australia are young families. I want to ask you this question for those young families. What are the 2 or 3 things they should put in place straight away so their child is looked after if the worst happened?
I'm really glad, Sagar, you asked this, because this is a very common situation, particularly in young families and migrant families. People come here, they start their life, they buy assets, and their children are young, and something happens, like if one or both the spouses die in an accident. Have they planned for or made the safeguards? They have planned ahead for that. So in my opinion, what they could do is look at obviously doing their will and powers of attorney, think of who could be a guardian for their minor children. If they have substantial assets they want to protect, look at the testamentary trust structure for the children, setting up trust, whether they want to set up the trust at what stage, when the first spouse passes, or at the stage when both of them have passed, and that's when they want to create for the children. So they need to take all of those decisions. Plus, they should also be thinking about who they want to appoint as executors and trustees. This is a big question they have in their heads, or they're not able to have ready answers for who they would like to appoint. Because mostly nuclear families are here, and they have their extended families back in their home country. So many times they find it difficult to decide who to appoint. But these are important decisions, and they should take some time to, decide on these important things.
Yeah, because most of them, they don't have any relatives over here. They don't have any, extended family over here. So it becomes kind of a difficult situation for them to understand and to decide who can be the guardian.
Guardian or executor, those are important roles, and that's where the work of the lawyer is important to guide them, who could be and who could not be, or what they are thinking. They should go with that option, or there is any other option, or if there are no options, then what they should do. So advice from a lawyer is the best bet, or that's what they should do, and also control that. Maybe in their will they can control the timing and the amounts as well, what they are giving to the children. So they could think about. I had mentioned this, not having the children get everything in one hit at 18. So control the timing of the inheritance, and that could protect the money from being misused or securing it.
But of course that's a tailored advice. Moving on, Simran, most people know that they need a will, but not everyone understands power of attorney. Can you explain in simple terms what a power of attorney does, and when it actually kicks in, and why it's something people should put in place before there's a crisis?
You've touched a very important topic, and this is one which people don't think about until it's too late. So wills operate after you pass away, but power of attorney is about protecting you while you are still alive. So I tell most of my clients when they ask me what a power of attorney and what's the use of doing that, and I say, power of attorney is more important than your will, because you're still there, and if you lose mental capacity, like for example, if there's some illness or accident, someone needs to have the legal authority to make decisions for you. Now, these decisions could be financial decisions, mostly financial decisions, because somebody needs to pay your bills, decide on how if you have assets and you need money, somebody needs to have that power to sell the property and get the money for you.
Right.
And sometimes also personal and medical decisions. You're in a hospital situation and you are not in a position to make any decision about your medical treatment. So have you put in place those documents for financial, personal and medical powers and matters? And the big thing is when people don't have these documents, and for some reason they lose capacity, their family may have to go through a tribunal process, like VCAT in Victoria, or in New South Wales it is the NCAT, which can take time and could add stress to an already stressful situation that they are going through. And obviously there'll be legal costs as well to go to the court.
True. Now, lastly, Simran, I want to touch on DIY wills. Now, DIY wills are cheap and they're quick. But from what you see, what are the biggest mistakes people make? And what's the red flag that means it's time to get the proper advice?
Okay. In our practice, day in, day out, we see these wills coming through. People have done it themselves. And also in most of the dispute matters in court cases, we see those wills being challenged. The most common issues that I see is they have not signed it properly, not properly witnessed. So there are mandatory requirements, right, for signing a will, which are formal requirements under the legislation. I think I remember seeing a will where the will maker hadn't signed and the witnesses had signed.
Oh.
There was no signature of the will maker. So you can imagine.
Yeah, that's illegal.
if it's signed in, like when we have the signing meeting in the office, the will maker comes in, we witness it and we make sure everything is done properly. But if they are doing it themselves, probably because of stress or confusion. They might have missed to do that. Then the other thing seen is many times there's unclear wording. Like if the words they are drafted, you can't make out what the intention of the will maker was. Now the will maker's already gone. They're dead. So who do you ask? If it's done with a solicitor, there are file notes that we have, right, of what the intention was and what they meant.
Right.
But when they do it themselves, the intention is not very clear if the wording is not proper. The other thing that the do-it-yourself wills could miss is not taking into account your superannuation, succession, nomination, or when I discuss joint assets, not considering whether it's joint tenants in common, those sorts of issues.
Right.
Another thing could be complex scenarios like blended families, as I mentioned.
Yeah.
The provisions relating to such situations, it's a high risk one.
Yeah.
And that needs tailored advice. So best not to do it yourself when your family circumstances are complex.
Makes sense. Thank you so much, Simran. Thank you for your time. The podcast has answered a few critical what-if scenarios, and I really, really appreciate your time.
No problem, and I'm glad all these answers will the listeners find them valuable. And thanks for having me.
Thank you for listening. This is Sagar signing off. Please do subscribe to Indian Link Media Group on social media and download Indian Link app, available free on iTunes and Android, to listen to music, live talkback shows and recorded shows 24/7.